oral application of Mr. Richard Adroli, learned counsel for the respondent, seeking leave of court to amend the respondent's answer to the petition by expunging paragraph 15 from it, and upon listening to the oral reply by Mr. Arias Lukwago, learned counsel for the petitioner, we are satisfied that the intended amendment does not prejudice the petitioner if granted. The copy of the Hansard, which contains the proceedings relevant to whether Rule 111, Sub-Rule 5 of the Rules of Procedure of Parliament was suspended or not, is already part of the annexures to the respondent's affidavit filed in this matter. The application to amend is accordingly granted. The respondent is given 1 day within which to file and serve the additional submissions highlighting the effect of the amendment on their submissions which are already on record.
One page.
The said additional submissions should not exceed 1 page. Counsel for the petitioner shall likewise file a response within 1 day from date of service. Course of this application shall abide the final outcome of the petition, which is so ordered.
Once we have received all the submissions in rejoinder on Monday the 20th, judgment will be on notice. We earlier on allowed you to rejoin by Monday. Yes. So judgment after that will be on notice. Right.
Constitutional application number 1 of 2020 on the withdrawal of the application in view of the fact that the petition has been heard in court this morning. The application is granted. The application is therefore withdrawn. The application is therefore dismissed. It is therefore dismissed upon withdrawal with no order as to proceed.
Obwesige commissioner erina kufaananako nga motion ejjako bwijjamu obuyinza president erina okubeera nga ewagiddwa bammemba abatakka wansi wa half oba kitundu kyabo abalina right okulonda mu parliament. Bammemba abalina rights okulonda bali 529. Half yabo ebiri mu 260 n'omusobyo. Kakati naye abaakuba akalulu bonna ng'obagasse wamu, abaagamba nti Honorable Zaake aveeyo, abaaga nti asigaleyo, n'abo ababstaininga bonna toto baali 161. Kakati ekyo kikulaga tebalina ate tekiri ni dispute, nabo bakikkiriza, naye ne bagenda maaso ne bwe bakola. Ekyokubiri kyekyokuba bafuujinze ne ripooti ya Parliament. Rules za Parliament era zigamba nti ripooti eya Honorable Katuntu gye yaleeta yalina okubanga eriko emikono gy'abamemba kimu kyakusatu ab'akakiiko ng'ekimu bamemba abalituula akakiiko ako bali 36 naye abaali basayininze baali 11 nga ne chairman kw'omutadde, meaning nti mu kifo ky'abamemba 12 abessalira abali minimum baali tebaweze. Kati parliament kye yakola ekitujje n'enviiri ku mutwe nga bamaze notuwa certified copy kiraka certify nze nti eno copy ya report ne tugireeta mu kooti wamala ogiraba ne baddayo ne bateekako member wa Kole County North n'asayininga ne baleeta nti kati bali 13 abasayininga nga olaba nti yefojjale yennyini. In fact era tusabye kooti nti oyo member wa parliament akangavulwe kubanga highest level of integrity ogisubira mu parliament, so member wa parliament ayinza kukola kintu kifaanana bwe kityo. Ekyokusatu kwe kubanga baleeta motion y'amapenduzi nga bagisimagolinze busimagolinzi. Rules ziraga nti bw'onooba onojjamu commission obwesige oleeta motion n'ofuna bammemba kimu kyakusatu ne bagisayininga ne bagitimba ne ku notice board ne bagitwala ne wakiraka tu parliament sergeant at arm n'abeerawo ng'alaba ali nti basayininga oluvannyuma ne bagiteeka ku order paper ne bagidiscussinga. Naye olunaku olwo lwe baateesa ku order paper tekwaliko kintu kya sensa. Honorable Mapenduzi yali atandise okukola ku motion eyo naye ne batagitwala ku order paper. Kati bwe bagenda ku order paper kwaliko lipooti ya Honorable Katuntu, kati awo ndi omugenyi waleetera amendment tubaleetemu n'ensonga endala, then tebakomye ku ekyo ne baleeta ne motion y'amapenduzi ne bagiyingirizaamu awo. Tulina decision za kooti nnyingi nnyo ne gye tutavaamu eyatogikwatako bwe baali baleeseeyo eky'emyaka 7. Toyinza kuleeta mu kintu n'okikukusa n'okiyingizaamu nga tekibadde mu biri ebyasoose. Kaakati bano kye baakola ne bakukusa mu lipooti ya Katuntu ne bayingizaamu motion y'amapenduzi bwe pa ne bagiwagikamu wali. Ate rules zigamba commissioner alina okugenda mu kakiiko ka Katuntu yeewozeeko, kati tewali nawe yeewolezaako. Ate bagamba naye parliament nga tena debatinga bamuwa notice ya nnaku 5 nti parliament ejja kutuula katugeze olwaleero Lwakuna ne bagamba mu nnaku 5 okuva kati parliament egenda kutuula era bagenda kuteesa kukugoba ku bwa commissioner. Naye order paper tekyaliko ne batuuka wali bakiyingizaawo buyingiza so tebamuwa right kwewozaako. Kati bo babadde bagamba rule eyo egamba nti speaker ajja muyita yeewozeeko mbu bagisuspendinga. Adolf Mwesige wadde agamba mu affidavit ye naye oluvannyuma ate bakimenyeewo ne bagamba tebagisuspendinga n'ate era nga tebamuyita kwewozaako. Ssemateeka waffe mu article ya 44 agamba right to a fair hearing, omuntu ekwewozaako kiri absolute, tekikyusibwako, eddembe terikwatibwako. Tojja condemninga omuntu yenna, thou shall not be condemned unheard. Ekyo twali kisubidde nti mu parliament mu article y'ensanvu eri charged with the duty of protecting and guarding the sanctity of the constitution should have been the vanguard in protecting that right. Unfortunately they flagrantly violated it. Kati zeze ensonga zetutaddeyo nga tugamba nti kooti esaze mu parliament bye yakola era si ku lwa Zaake yokka nti kudda ku bwa commissioner naye ku lw'obulungi bw'eggwanga okuba nti etambulira ku rule of law, olw'obulungi bw'eggwanga okuba nti eweekitiibwa ssemateeka, olw'obulungi bw'eggwanga okuba nti parliament naye eddamu ensa nga tekola mob justice.
Era ekanso kira kulaba nti naye avudde the fund era nga kyebakola tubeesiga tumanyi nti basobola okukikola naye nga bwe tumanyi nti no munnange ebintu mu Uganda n'ebitasoboka bibeerawo genda maaso ne Parliament emanyi bye yakola byennyini nnyini era mubira bulijjo for this thorough work they have done in terms of protecting our constitution, you know, ensuring the rule of law in this country. And in that regard, specifically, I need to thank the rule of law general, our Lord Mayor, and the lead lawyer in this case for the work really well done. And if at all we were given an opportunity for oral submissions, you'd have seen who the rule of the lawyer in Council Elias Lukwago, who he is. So he has done it so well, including Council Aaron Chiza, my colleague here, Ivan Bowe, is a fellow youth, and also Council Katana, my brother and comrade Marvin, and many others.
Had a series of processes which have been undertaken from the during. We've been findings and affidavits and subsequent submissions. Everything regarding the hearing of this matter, and we are glad that finally it has been the process has come to the conclusion, because the submissions are on record. We had to iron out a few issues of procedural nature, and what is left now is for court to deliver their judgment and the assurance that they have given us. It will be on notice, which we expect to be given expeditiously, because this is a matter which touches about the Constitution of the Republic of Uganda, about the Parliament, about fundamental rights of all Ugandans. And we elaborate all of them. But the gist of it all is that Parliament did not have quorum because it is clearly stated in Rule 105, Rule 110 of the Parliamentary Rules of Procedure that for a commissioner to be impeached, there must be votes of at least a half of the members with the voting rights in the Parliament casting votes in favor of that particular motion. Let me summarize it, sum it up this way. That the vote that should remove a commissioner should be supported by at least a half of the members of Parliament with voting rights. The evidence we have adduced before court is that there are 529 members with voting rights. But those who voted in total were 161. In total, there were 161. Those 4 are against the motion. You get it? The other thing is, the Mapenduzi petition was smuggled in during the debate. Yet the rules of procedure provide that the petition should be signed by at least a third of the members, taken to the clerk to Parliament, and before the sergeant at arms, members append their signatures, and so on and so forth, before it is tabled on the floor. But when they were debating this matter, they never considered the motion brought by Mapenduzi. It was just an amendment by Ndio Mujenyi that we include in the report of the Katuntu Committee a motion to censure the commissioner. That was illegal, obviously, because we have actually brought evidence to court that Parliament committed forgery. How? The report of Parliament was signed by 11 members, contrary to the rules of procedure. Because Rule 197 provides that the report of any committee must be signed by at least a third of the members of the committee. The members of the committee were 36. A third meant 13. But those who had signed were 11. No, a third is 12. But those who had signed were 11. A third is 12. They were short by, of the required numbers by 1 member. Now, when we filed our case, with a certified copy of the answer and the report itself, then the MP for Kore comes and appends his signature. And then they claim that he had also signed, when on the original report he had not signed. That is a clear case of forgery, which were presented before court. Finally, the issue of the right to a fair hearing. The rule we have been talking about, 111, sub-rule 5, provides that the Honorable Zaake ought to have been given a right to be heard after all the debate. But this matter was not even cause listed. It was not on the order paper. The matter of the removal of the commissioner was not on the order paper. On the order paper, they had the Katuntu report. And the Katuntu report was not about censure, because the Katuntu report was about an apology. So after bringing in the issue of the report of the Katuntu, saying that there should be an apology, Ndio Mujenyi brings in an amendment, and then Mapenduzi also moves a motion, and then they unleashed mob justice on him. All that evidence has been adduced before court. And there's not been any controversy, countering of the same by strong defense from the other side. So basically, those are some of the issues. And of course, the other issue that one cannot be a judge in their own cause. When you look at the record and they answered, the speaker is on record saying this is a personal matter, and she was personally interested in it. And she even indicated and said, we want this matter, we must take action. She said, I'm also a human being. Then she made even a question which I feel like I shouldn't even mention here. So those are things she poured out her emotions and said, members, we need to act. And then she said the whip should whip all of us so that we take action against the Honorable Zaake. Where is now the element of impartiality? Fairness. Substantially, the Attorney General says they suspended some of the rules we are talking about. That's what they are saying. But they forgot that by suspending those rules, they deprived themselves of the authority and powers to proceed with the debate and taking a decision. So essentially, they have no rules under which they took the decisions if they insist that they suspended the rules. And secondly, the rule on quorum. How do you suspend it when the provision is very clear that at least half of the members with voting rights should support the motion? Then how do you suspend it? It's couched in mandatory terms that at least half of the members must support the motion. Then how do you suspend it? Actually, even if you are to suspend it, you needed to have quorum to take a valid decision to suspend. So you can see the whole proceedings were tainted by glaring irregularities and illegalities. The proceedings were tainted by glaring irregularities and illegalities.